What have you written? What have you written here?
A mistake is there, but
Rectify and move on the next day. These are not to be.
my junior.
Your Lordship, may I be permitted to mention a matter?
Yes, yes.
It is a second appeal, Your Lordship. It was filed on January 5th, 2021. It was last heard by Your Lordship and Honorable Justice Supreme Rajshekhar Mantha on August 3, 2023.
Is it? It is a
It was last heard by its second appeal, Your Lordship.
second appeal. Huh? Last
It was
heard.
last heard in August
Last
2020.
heard means
Last order was passed in this matter on August 2020.
through that order, what was passed?
There were substantial questions of law which were prepared. The respondents were directed to serve us a paper book, and thereafter, Your Lordship had also directed for this matter to be placed before the single bench, to be mentioned before the single bench.
So it was admitted.
It was admitted.
How many substantial questions of law were framed?
Three or four, Your Lordships. I will point out, Your
You
Lordships.
need not see it. Need not go through.
Okay, Lordship.
You are representing the respondent,
The appellant, Your Lordship.
appellant. So you must be aware of.
Your Lordship, this is a change.
So now, what do you
Your
intend?
Lordship, for inclusion in the list, because the Honorable Division
What
Bench
for?
for hearing of this matter. Your
Hearing.
Lordship. Yes, Your Lordship.
The
Expeditial
transcript
disclosure.
record, first appellate court record has arrived.
It has the special messengers was directed to, but I think there is some problem is not able to.
Go and check it. Otherwise, the department would have intimated you. Notice would have been served if the trial court record and the first appellate court record had arrived. Go and check with the department thereafter.
Okay, Lordship. Grateful.
Item number 3.
Club matter. Club
Yes,
matter.
yes, madam. Club matter. This is
You are representing the respondent.
my lord.
Where is the appellant? Club.
My lord, I have, my lord, already draw your lordship's attention relating to the plane, schedule of the plane.
Learned counsel.
My lord.
The presence of the appellant is required.
Appellant, my lord, most probably completed his submission.
They have completed, but in their absence, can we take up the matter? Can it be heard?
It is up to your lordship. If your lordship not take up, then your lordship kindly my humble submission on 28 at 2 p.m. As because on 21st,
Learned counsel. We have an hour today.
my lord.
On Friday, this bench will be available for an hour.
No, my lord, usually, my lord, Friday, my lord, from the 10:30, my lord, division bench not, my lord, functioning. Usually.
This bench will be available during the first hour on Friday. On Friday, that is 21st. If none is representing the appellant, why the display হচ্ছে? Intimate your adversary, who is the advocate on record, that the matter will be taken up on 21st at 10:30 a.m. পেপার গুলো আলাদা আছে আছে কিনা জাস্তি Learned Counsel, thank you. Learned Counsel, written notes of argument have been provided on your behalf.
Not had the brief today, my lord, so
My lord, written notes of argument, my lord, before the, my lord, first appellate court, my lord, filed by both the parties.
I'm not asking about the written notes of argument filed before the trial court or the first
On,
appellate
my
court.
lord, before your lord.
Herein, as because they have completed their submission, that's why I was asking. Let us start.
If your lordship desires to submit written notes of argument,
Then
then my lord, your lordship can direct both the parties file their written argument before your lordship.
it is
That
being
is, my
directed.
lord,
It is being directed to file the written notes of argument, but let us complete the oral submission first.
My lord, my humble submission is this, my lord. I have, my lord, already filed the suit 1971. And thereafter, I succeeded in the suit. And they preferred an appeal before the, my lord, learned first appellate court. And that is
Affirmed by
also
the first appellate court.
affirmed the said judgment. But, my lord, till 1971, till today, we are suffering for not allowing us to using the property. Now, your lordship, on last occasion, I draw your lordship's attention about the plain, schedule of the plain and written statement. Now, I am drawing your lordship's attention only to relevant point of the cross-examination of the plaintiff side. Plaintiff side, cross-examination.
Trial Paper book, in which page is the substantial questions of law? In paper book?
My lord, only one substantial question of law framed by at the time of
Admission.
admission.
And thereafter, as far as my memory goes, another one has been added
that is
during the
added
time
by
of-
your lordship.
during the time of
That is
hearing.
During
During the
course
time
of
of course of
hearing,
hearing.
your lordship added one subsequently.
Altogether, two substantial questions of law.
Now, my lord, my question is whether, my lord, at the time of admission, the substantial question of law already framed, thereafter any substantial question framed or not. That is my question. And my lord, I answered this point.
I'm not clear. What is your query?
My lord, my query is, my lord, at the time of admission of the
Hmm.
appeal,
Uh,
the
One substantial question of
one
law has been
substantial
framed.
question have been framed. And my lord, subsequently, my lord,
At the time of hearing,
another, my lord, substantial question of framing,
substantial question of law can be framed or not?
No.
Yes, it can be framed.
it can be framed.
It can be
Then, my
framed.
lord, I shall
Altogether-
reply that point also. That substantial question of law. On the point
Of
of
that you
that
have.
substantial question of
So-
law, I also submit my submission. My lord. Now, my lord, your lordship, for the deposition of PW1,
You are referring to
cross-examination of PW1. Subhash Mukherjee.
cross-examination of PW1 dated
19 January 2006, item number 55. Serial number
Yes.
55. Middle portion.
Hmm.
The suit property bears, your lordship got it?
yes, Pierce, present plot number 2248.
French, it will be French,
Hmm.
but it will write as part. French plot number, area 0.76 acre. Next line is very important. On the northwest portion of the suit property, the defendant portion Kishore Sangha is situated. Therefore, my plaint very much disclose the schedule of the property, and northwestern side of the schedule of the property, Kishore Sangha, club of the Kishore Sangha is situated. There is a Pakka building of Sri Sri Horilila Sangha Dhoi on the northeastern portion of the suit property. Northeastern portion of the suit property, সেখানে there is Horilala Sangha. And southeastern, northwestern portion, there is club. There is an old Pakka Tulsi Mancho on the southern side of the club room of the suit property. I cannot say whether the members of Kishore Sangha use so tree or suit plot as playground. Cannot say. Next. '56. Last portion. Durga Puja is held.
Council, why have you referred to the question number 55?
55 as because they club and Horilila Sangha.
Is there any discrepancy as regards to the description of the suit property?
The description of the suit property, no, not any, there is no
It can be identified.
Only question is this, that Horilala Sangha is there, and on the western north side of the Horilila Sangha, some pupil hanging a signboard and claiming that is their club. Club has no separate entity. That is my submission. And next, your lordship will find serial number 6, last sentence. Your lordship got it?
Is the club registered?
They claim registered, but they have not produced a single portion of papers relating to their registration or relating to any government document relating to
Not
their
any-
establishment.
Not any iota of evidence as regards to registration.
Actually, which your lordship will find from the two judgments. Trial court judgment clearly disclose each and every pros and cons, and appeal court also, first appellate court also disclose everything. Your lordship, only point is this, that whether their temporary possession can be accepted as the any right of possession or not. My humble submission is this, your lordship knows better than me, that so many judgment of the Honorable Supreme Court says that temporary possession is not any right of possession without any valid document of the title.
So according to you, they were given the permissive right to have
No,
the Durga Puja,
we have
To
not
conduct-
given
to conduct the Durga Puja.
Durga Puja conducted by the Horilila Sangho and club and Horilila Sangho. The person involved, both the organization are the same locality. Therefore, the Durga Puja organized by the local people, and in the said local people, Horilila Sangho, people of the Horilila Sangho, as well as people of the alleged club, both are participate in the Durga Puja.
So according to you, they are not different entities.
No. Then Kishore Sangha does not perform Saraswati Puja. No other puja are held. Got it?
Hmm.
No other puja are held in the Sud property other than Durga Puja. Saraswati Puja is not performed in the club room of the dependent club, but the same is held in Horilila Sambodhani Sabha. The Horilila Sambodhani Sabha is in the eastern side of the Sud property, not in the northern side. And our suit not against the property of where Horilila Sambodhani Sabha is situated. Our suit is relating to a vacant portion which absolutely right title, interest and possession with us. But the club, some person unauthorized in the name of an unauthorized club, forcefully and unlawfully, they are restraining us to enjoy my property, our property. Next, the club room of the defendant club is situated in the western side of Horilila Sambodhani Sabha, having a common wall. The lordship kind mark 58. Serial number 58. The club room, the lordship body,
Having a common wall,
common wall. Then, my lord, my humble submission that Horilala Sabha side of the north having a common wall, and they only hanging a signboard of club on the wall of the Horilala Sambodhani Sabha.
yes.
The Sabha is a two-story pakka building.
Learned counsel need not go through the entire evidence.
No, enter, not
Need not go through.
required to enter. Only 58, 59, 60, 61. 4 points are very much relevant in the proceedings. Now, your lordship,
The Shobha is a two-storied Pakka building.
my lord, Sabha. Sabha is not the subject matter of this suit. Sabha is out of the suit. We permitted the Sabha to continue Hari Sankirtan and allowed their portion. But they, the club allegedly hanging a signboard and claiming that they have some right. My lord, kindly, my lord, 98 or a one, your lordship very soon.
98.
Of
You were
this-
referring to 59, 60 and 61?
That
Complete.
all right. Now your lordship kindly see
1
only
minute.
98.
1 minute.
Southern portion of the club room,
1 minute, let it pass. $98.
98 and 90. Last but one. Last
Yes, 98.
90. Southern portion of club room and southern portion of Hulila Sampurti Sabha is a complete package. Southern side, both the Hulila Sabha and club, southern portion package. State cultural programs, puja are not held in the Sud property. Sud property nothing held in the Sud property, but in the vacant land. I cannot say the exact measurement of the vacant land, length, breadth, and
Learned Counsel, this has been deposed by,
deposed by the PW1 Subhash Mukherjee.
uh, he was then the, he was this,
He was the one of the respondents.
no. Which post he was holding in that club?
No, I am not. I am the owner of the land.
Which post was he holding? PW?
He is
Oh,
not the
acha, acha.
owner.
Oh,
He is
PW1.
PW1.
Hmm.
He is the landowner.
Landowner. Yes. Learned Counsel, if you bring forth any submission of theirs, this is your submission. This is your deposition.
My lord,
Any deposition of theirs.
my lord, I am coming back. I am coming. Before coming the deposition of the DW, I am drawing your lordship's attention. PW2 cross examination.
Hmm.
Point number 17, 19, 20, 26, 27. My lord, may I read, my lord?
Yes.
Not a fact that Kishore Sangha was established in 1948.
Need not read the not a fact ones.
Not a fact.
Need not go through. Not a
Need not.
fact.
Then I have nothing to say about this.
I cannot say the exact date of display of signboard of Kishore Sangha. I cannot say the exact date of establishment of Kishore Sangha. Thereafter,
Thereafter,
any other point?
point number 26, 27,
This is not a fact.
not a fact. Now your lordship kindly come to the DW,
1.
DW1. Statement of the DW1.
In which capacity did he depose?
He
This Parvati
deposed.
Chandra Das. In which capacity did this Parvati Chandra Das?
Parvati Chandra Das, DW1, he is deposed. No designation or any other thing is recorded in his evidence. Only I have made party as defendant 1A, and I am, my lord, kindly, my lord, see, my lord, the plaintiff, defendant.
Which point were you referring? As regards to DW1,
Parvati, I am referring as para 5. Para 5,
examination in chief.
examination in chief. That
Yes.
that there is an organization, namely Horilila Sambardhani Sabha, and the said organization has got Pakka two-storied building in the northern side of the suit property, and the club room belonging to the defendant is also situated in the western side of the building of the Horilala Sambardhani Sabha. Admitted my submission, my claim that Horilala Sabha, it is also situated in the western side of the building of Horilala Sabha, in the continuous western side. He has admitted that building of the Horilala Sabha, there is the club. And my lord, not a fact, not law, not required, submitted by not required. Is my lord, your lordship kindly cross examination, point number 8. Cross examination. I used to live, got it?
30.
38. English type. This is English type.
I used to leave home for office
Ah,
around 8 a.m.
8 a.m. and return by 8 p.m. Therefore, he has no scope to participate any games or anything regularly on the
Next point.
endpoint. 39. I have my own dwelling house which was constructed by me in 1971 after purchasing the land.
We are not concerned with this.
71, after
property.
71, he has come to the locality. But they claim that their club established in the year 1948. Someone claimed it is established 1961. Someone claimed it is established 1968. Now it is admitted in the cross examination that he constructed his dwelling house 1971.
Next point.
Next point, prior to that, I used to reside my ancestor property in the Sudpapa locality.
This relates to that point only. Next point.
Next, my dwell, I cannot say the dag number 42. I cannot say the dag number, Khotiar number of my
Learned Council, question number 47.
47. 47. Kishore Sangho was registered in 1961. I have not filed the registration certificate. I am the secretary of Kishore Sangho since 1946, but no document, nothing else. I was in school, this is very important, in 1946, and I was nearly 13 years old. This is believable, my lord. I am asking myself that a person having age of 13 years, became the secretary of a registered club.
That will be taken into consideration. Next point, learned counsel.
52. My lord, sorry, my lord, before going to 52, your lordship kindly consider the 48. 48. The club has resolution book, minute book, meeting book, books of account, but I have not filed it.
So according to you, neither any certificate of registration nor any
Valid document.
document as regards to the club has been proved by the defendants
Defendant.
or exhibited by the document by the defendants.
By the defendant. Even they have not said the,
What have they exhibited? What have they exhibited?
they have exhibited some invitation card, some councillor's letter.
And apart from these two,
But only one. Not produce anything.
exhibit A, souvenir.
Souvenir.
Exhibit B, copy of
Exhibit.
where are those exhibits?
Exhibit. Document. Defendant's document. That is page 6 of the paper. Souvenirs, some letter, and one.
Learned counsel, have you taken back all the documents which were provided,
Yes,
which were marked exhibit? Learned counsel,
yes.
you have taken back all the documents which have been exhibited?
But I have to take the brief,
Hmm?
but
That is in the tin box.
Tin box. দেখুন তো tin box আছে? B series, C series, and D series are copy of letters.
Copy of letters.
E series and F series are copy of applications.
Copy of application.
These are the documents filed by the respondents. And you have taken back all the documents. Learned Council, you have taken back all the documents.
By producing certified copy.
Certified copy. That ought to be. Without producing certified copies, where are those certified copies? After the completion of today's argument, kind enough to go through the record as regards to the certified copies of those documents. এটা রেখে দিই, এটা defendant এর। আপনি আমাকে একটু দেখতে দেবেন, রেকর্ডটা দেখবেন, documents completion of submission. Yes. Now, next.
Next, my lord, after completion of the evidence of PW and DW, before completion of the framing the issue before the trial court, I am only draw your lordship attention to page 6 of the trial court judgment. Consideration of issue number 4, 10 and 11. Page 8.
Page 8.
Page 8. All these issues are taken up together, being intermittent, having nexus with each other. It is the case of the plaintiff that the defendant club is a trespasser, where it is the case of the defendant that they are in possession, advance to the right title and interest of the plaintiff. It is the submission of the learned advocate of the defendant that Horilala Sambardhani Sabha and defendant club is in possession for more than 12 years. As such, where prayer for mandatory injunction will not service. Plaintiff will have to pray for recovery of possession by praying sufficient court fee. Otherwise, if any decree is passed, same will be infectious. He also submitted that the learned investigation commissioner report, even though then, my lord, eligible portion I am not reading, but the court is nothing but a piece of evidence. Learned advocate has the plaintiff submitted that the club is a then, my lord, I have to, my lord, see the original document. That is also illegal. Functioning. Learned advocate for the plaintiff submitted that the club is a
ট্রায়াল কোর্টের জাজমেন্টটা যেখানে আছে, বুঝেছো? ট্রায়াল কোর্টের জাজমেন্ট, ইয়েস।
as such cannot claim adverse possession. Moreover, it is the defendant who must prove construction for the there is some constructive possession, as the onus is upon him who claim adverse possession. He has paid for recovery of first possession from a trespasser. As such, there is no question of payment of court fees. It has been held in most probably 1996 Cal 84 that in case of failing to prove hostile aminias for more than 12 years to the knowledge of the title holder or his predecessor in interest, the possession of one claiming adverse possession would be preserved to be permissive in nature. It is settled possession of law that mere possession, even of a trespasser, will not constitute adverse possession. It is settled proposition of law that mere possession, even a trespasser, not constitute double thinking, constitute adverse possession unless accompanied by open assertion of his title. It is also settled law that the onus lies upon the party who is pleading adverse possession. My lord, kindly, my lord, consider that I think, my lord, your lordship framing the substantial question, answer of the substantial question of law, your lordship framing during course of hearing, your lordship will get the answer of the said substantial question of law from this paragraph. It is also settled law that the onus lies upon the party who is pleading adverse possession. Anybody pleading adverse possession has no equity in his favor, since he is trying to defeat the right of the free owner. It is for him to clearly plead or establish all the facts necessary to establish his adverse possession. One has to clearly prove the date, time, and manner of conversion of possession to adverse.
Lord Counsel need not go through the entire judgment.
My lord, I am, my lord, only rely on these 4, 10, and 11. Issue number 4, 10, and 11, and the learned trial judge as well as the learned first appellate judge consider these 4 issues are very relevant. And your lordship will find the entire thing of the judgment from the answer of these 3 issues. And for that reason, I am drawing your lordship's attention with answer of these 3 issues. Then your lordship will kindly consider the 3 issues answered by the learned trial judge as well as learned trial appellate, first appellate court. Now your lordship can consider my written argument which the respondent filed before the learned first appellate. না ওটা তো নিচুর কোর্টে। হ্যাঁ, তো ওটা তো রেকর্ডেই আছে, ওটা তো তোমাদেরকে দেওয়াই আছে, তোমরা তার উত্তরও দিয়েছো। Argument filed by the respondent before the first appellate.
That one.
My lord,
That one.
my lord, as because my lord,
Please not go through your written notes of argument.
Written notes of argument in relating to the second appeal not yet filed. Your lordship not directed to file.
You only refer to the judgments. You only refer to judgments of the trial court, judgments of the first appellate court,
Judgment of the trial court,
and the first
I
appellate court,
referred,
which are in your favor.
that is, my lord,
and
issue
which are
number,
against them.
issue number 4, 10 and 11. Those
You are
three
relying
issues,
upon those issues only. Discussion.
three issues discussed by the learned trial court as well as first appellate court. And I rely on those three issues, and on my humble submission, your lordship will find the entire thing from the observation and
Any authorities to be furnished?
my lord,
Any citations, judgments to be furnished?
my lord, actually, my lord, the judgment on the basis of which the appellant at the time of admission of this appeal shows that is also not applicable in favor of the appellant. And another judgment your lordship will find. I have not the copy, but citation is there here, and that is কোথায় গেল গো ওই নাম্বারটা? আমরা নাম্বারটা কোথায় নাম্বার? My lord. My lord, one judgment, my lord, my lord, relied on, but copy of the judgment is not in my
Give
hand.
the citation.
That is, my lord, it was held in the case of Subhash Chandra Bosu versus Belgachia Friendship, 2019, 4 ICC 44 Calcutta. That they are playing with
2019, 2019 4.
ICC 244 Cal.
This number, Subhash Chandra.
Subhash Chandra Bosu versus Belgachia Friendship. Consideration of this judgment is, it was held in this case that mere playing of games or holding social function on property of someone else does not confer possessory right amounting to adverse possession in favor of the club. Since such adverse possession begin and terminate every day when games and social welfare program comes to an end. This is very vital judgment, and I think your lordship will consider the entire judgment, and the judgment relied the appellant at the time of admission of appeal, where your lordship will find that they there is the question that specific dispatch 34 not lie, but here admittedly defendant not is a permanent possession holder. They have no right or title or possession in the suit property. Suit property. So not admitted that they participate some social function, they participate some game, they participate organize some puja, even they have no right of possession in the suit property.
Anything more to be submitted?
I have nothing to say. I only rely on the judgment of the two courts. In addition
Honored
to
counsel.
this,
In reply.
My lord, I am led by Mr. Banerjee. I need one weekend, my lord. Kindly fix it next week, my lord.
Ask Mr. Koyan Banerjee
He is
to come
doing
prepared on Friday at 10:30.
Friday. He
Friday
shall not be
10:30.
available, my lord. Friday shall not be available, my lord. For such reason, I am praying next week, any day, my lord, he can answer the.
So come prepared on 28th.
8. Yes, my lord.
My lord, can you, my lord, take up at 2?
No, at it will be taken up at 10:30 on 28th.
Then, my lord, one leave, my lord. My junior will be here. I will, my lord, engage in another matter. And, my lord, after
It
12,
is up
my
to
lord,
you, Lord. It is up to you, Learned Council. It is pending since long. That's why the matter has been fixed. Mm,
For item number 5, I am for the respondent led by Mr. Shumani Chokla.
Probably appearing. Why is the CA matter will appear in the
That's why I keep your
item number 5. Yes.
Your Lordship, I am for the appellant led by Mr. Dutiman Banerjee. He is in another court, so pass not today.
Request your learned senior to come prepared on Friday positively at 10:30.
Okay, sir.
Learned Council So why it is appearing under the heading part heard? Or no? For hearing.
For hearing.
For hearing. Ask request to learned senior to come prepared on Friday, that is 21st at 10:30.
I'm grateful.
अच्छा, नहीं,
তিন নম্বর তো
হ্যাঁ, কোনটা?
যমুনাতে
অফিস রিপোর্ট আচ্ছা নেক্সট হ্যাঁ লিখলাম।
But in item 7, my lord, I appear for the appellant. My lord, I had submitted my written instruction to that effect. I wanted to withdraw the appeal because my lord, the decree has been executed. We have handed over possession to the respondents here. My lord, your lordship had passed an order, but I do not know why the order was never uploaded. It was passed long back. Your lordship had dictated the order upon my instruction. I have handed over the instructions much before, prior to the summer vacation, my lord. My written instruction is already on record. It was taken up. An order was dictated in open court, but I do not know, it was never up.
Where is the order? Where is
It
the
is pending.
who is representing you in the court? Who is representing you in the court? Is anybody
In the
present?
court, my lord,
Is
No.
anybody present physically?
perhaps not, my lord. No, my lord. My lord, I had submitted the written instruction that the appellant wants to withdraw the appeal as because it has become infractuous, the decree has been executed.
Learned counsel, you submit. What you intend to submit?
My lord, based upon the instruction handed over to me on 7th of March 2018,
Yes. Learned
lord.
counsel, on that
My-
day, did you have the wakalatnama?
on which
7th of
the
March 2025,
7th of March 2025,
the date on which you have handed over the instruction?
Yes, my lord, the wakalatnama is on record. I've submitted the wakalatnama. And the wakalatnama is case
Where you have
status shows
submitted? Where you have submitted?
the department, the state case status shows the wakalatnama has been submitted.
This has been submitted on 22nd of May.
But it was
22nd of May 2025.
deposited in the department. But my lord, the instruction came to me along with the wakalatnama prior to that, because there was no
Prior to that, that's why no order was recorded. No order was passed.
My lord, subject to lordship's correction, my lord, the department at that point of time, the wakalatnama was not on record. Your lordship perhaps had called for a report from the department.
Yes.
And thereafter, the matter has never been listed. Lord, initially an order was passed, but as because the wakalatnama was not there, ultimately the order was never
So, learned
perhaps
counsel,
signed or uploaded.
learned counsel,
My
why
lord.
did you start with the word saying that order has been passed? It has not
My
been
lord,
uploaded.
my
Is
lord, the
that
order
the
was-
correct submission? Is that the correct submission?
Yes, my lord, the order was passed in open court. My lord, the steno took the dictation. Thereafter, your lordships perhaps inquired from the officers as to the whereabouts of the wakalatnama.
And
And
learned
thereafter,
counsel,
this was done.
you did not possess the wakalatnama at that relevant point of time.
But I
Did-
had.
did you-
Well, otherwise, how could, well, if I was not executed with the wakalatnama, why would the entity write to me with the instruction? Well, it was filed subsequently in the department in the month of May. But in the March, the wakalatnama had been executed.
Let me be clear.
Otherwise, my lord,
You continue. What you intend to submit, you continue.
my lord, the entity engaged me. Upon my engagement, the instruction was issued to me.
So that's why this order was passed on 24th of June 2025. Thereafter, Mr. Abhimanyu Banerjee, the learned advocate representing the appellate company, that is Measures United Insurance Company Limited, submits that wakalatnama has been filed on behalf of the appellant on 22nd May 2025.
My
In
lord.
support of his contention, the learned advocate files the case status which reflects the name of Abhimanyu Banerjee, but the record does not contain the wakalatnama. Let the case status be kept with the record. In such circumstance, department is directed to search the wakalatnama and tag the same with the record forthwith. This is the order dated 24 June 2025.
My lord.
In compliance now on 26th of June, in compliance with Honorable Court's order dated 24 June 2025, it is humbly submitted that a wakalatnama has been filed on behalf of the sole appellant by the learned advocate Mr. Abhimanyu Banerjee on 22nd of May 2025 without obtaining no objection from erstwhile learned advocates Mr. A.K. De and Mr. DIPTA, Dipto Bhanu Dutt.
My lord,
Learned
this
counsel,
report,
learned
my lord,
counsel,
this report has not been circulated. I do not have a copy of the
be
report.
circulated.
My lord, this report of the department that NOC, my lord, this perhaps, my lord,
Learned
at the time
counsel,
of deposit of the wakalatnama,
learned
objections
counsel.
are raised.
Yes, you
My
continue.
lord.
You continue. You continue your submission.
My lord, no objection was raised at the point of time. My lord, that is why I did not know of this. And number two, my lord, the panel of this insurance company, my lord, they have been depaneled. These persons who filed the appeal in the year 2008, they are not in the panel.
I am unable to explain to you. What objection? Who will raise the objection? It is no objection on the wakalatnama. That has been mentioned by the department.
I am referring
From
to
the
that
erstwhile.
only. I am referring to that only. The no objection for the erstwhile advocate on record who preferred the appeal initially in the year 2008 could not be obtained because those persons are not in the panel.
So now you are submitting this one. There is other provision also. There is provision. Go through the appellate side rules.
Appellate side rule chapter 9 deals with the fresh wakalatnama can be accepted if the client has executed it subsequently. Appellate side rules chapter 9.
Learned counsel, only one thing can be said. ওনার নামটা দিয়ে দিন। One Mr. What is your name?
Obhimanyu Banerjee. I am the equivalent record. No.
One Mr. Go through the record and take necessary steps. There
But
are
I could not
provisions.
hear. But I could not hear any of the dictation, my lord, because the order dictation was muted. Anyway, my lord, I will go through the order as well as the records.
Yes. Kindly go through the order.
My lord, I shall.
Uh, 21st of November. 28th of November. No. Please mention that. The matter will appear on 28th. In the meantime, you take steps
My lord.
after
My lord,
going through the record.
My lord, I shall.